HarperCollins presents In Harm's Way, the Memoir of a Child Protection Lawyer by Teresa Thornhill. Read by Emma Spurgin Hussey. Author's Note. To protect the confidentiality of the children, parents, grandparents, and other relatives I came into contact with as a child protection lawyer, and to comply with the rules to which I am subject, all the cases related in this book are fictitious creations. To invent them, I have combined, for example, elements of the background of real family A with elements of the trauma suffered by the child or children of real family B, with a little of the courtroom experience of real client C. In the process, I've altered names, ethnicity, ages, and genders of children and adults, as well as the attitudes of parents. The physical appearance, mannerisms, and words of all the lay people who appear in the book are entirely fictitious. Here I've given free rein to my creative imagination. I've also invented the names, appearance, personality, and attitudes of the judges, magistrates, lawyers, social workers, court clerks, doctors, and psychologists referred to. But the characters I've created are deeply rooted in my real-life experiences. In Part 2, I describe my experiences working in a number of local authorities, on their permanent staff in some, as a locum in others, over a period of years. My descriptions are not based on any one particular authority. Rather, they are intended to depict the working conditions in which local authority lawyers typically operate, and the stresses inherent in the work. Preface. Alice G. "Morning, Teresa," calls a male voice as I push open the door to the robing room. A fresh-faced young man sits at a table, 2 ring binders of court papers neatly stacked to his right, and a fountain pen in his hand. He looks like a rugby player in a pinstripe suit. "We're going to have some fun today, aren't we?" His thick blonde hair and neatly trimmed beard strike me as familiar, and as I drag my wheelie bag to the coat rack and kick off my trainers, I return his greeting. As I pull on my smart black shoes, it dawns on me that he's Simon, a junior member of my chambers. I ask if he knows which courtroom our case is listed in. We're in front of a lay bench today. Lay justices or magistrates to the general public, which is presumably what he means about anticipating fun. No self-respecting lawyer ever chooses to argue a care case before a lay bench, even if, like Simon, they're representing the local authority. For me, representing the mother, a lay bench spells disaster. I'll put up a fight for my client, but my chances of persuading justices not to place her child for adoption are virtually non-existent. Justices who sit on care cases are volunteers, who are not required to have legal qualifications. There's a selection process, following which they're provided with basic training in child protection law and policy. Once in court, they operate under the guidance of a legally qualified advisor, but he or she can only guide them as to the law, not the making of value judgments about the factual evidence they hear. As an individual who can afford to work for free, the typical lay justice is over 60 and white, and in my experience, most appear to hold socially conservative views. In recent years, efforts have been made to address the lack of ethnic diversity, particularly in London and other big cities, but in the regions where I've mainly worked, an all-white lay bench remains the norm. The use of lay justices to make life-changing decisions about the future of children is one of the most bizarre anomalies of the English and Welsh system of family justice. A decision to remove a child from her birth family against the parent's will and allow the local authority to place her for adoption, for example, should surely be made with the utmost care by a tribunal with all the relevant training and experience. But no, in England and Wales, in the less complex cases, we ask lay justices to shoulder the responsibility for making these decisions. During 30 years of practice, I've come to the conclusion that the explanation is relatively simple. Most of the children who come before the family court
Sample complete. Ready to continue?